Hello and Assalamu alaikum. My name is Muhammad Alam and I am a lawyer by profession and founder of Alam Law. As many of you know that Alam Law practice more specifically on personal injury side where accident victims or victim of slip and fall or insurance denial claim, people when they are in need, they need lawyers like us who practice personal injury and insurance litigation. Through this segment, today I am going to talk about legal signing a waiver of liability when you attend a park or a museum or, for example, trampoline park or any other playground. When you attend those recreational places, the facility will ask you to sign a document that's called waiver of liability, which essentially means if something happened to you, we are not liable. And that's a legal document, and it could be in a form of a specific document, or it could be just part of the form that you're filling in about your information. And underneath, there will be a waiver, which essentially means that the facility does not take any responsibility if you're hurt. So as such, what they're telling you, that if you got hurt, you don't have a case and you cannot hold us liable for your injuries. So what is that means, the signing of waiver of liability, and how that affect your claim or your injury claim if you got hurt? So first of all, number one, as a general practice, I always encourage people when you go and attend those recreational facility, if you sign any document, you must know what you are signing. If you are reading that, and if you're not comfortable with, you should speak to a manager or somebody there. But most importantly, reason is this: why we are talking about this issue in a segment where you got hurt, you complained to the facility, and they will show you that, oh, you signed this waiver of liability, which essentially means that we already told you that you can get hurt, and as such you don't have a claim. And people stop at that point and even do not consult lawyer to know about their legal rights. The courts are clear. It's not a blanket prohibition, even if you have signed a waiver of liability, because if the waiver of liability was signed at a situation where either you were rushed or you were given a document without explaining, or the waiver was written in a very small print at the bottom of a form that you were asked to fill, those are the waiver of liability that can easily be challenged, because court also look whether or not you were given an opportunity, you were explained the risk that you are entering into by engaging in certain sporting activities, or you were just not told anything, or maybe sometime misrepresentation, which essentially means that you were told to fill out a form about yourself, about your identity, your age, and underneath of a form there is a small fine print there without they explain you sign that document. That kind of waiver can easily be challenged. Lesson for all of us is, when you got hurt and if you made a complaint to the property owner or the facility owner, and if they show you that you have signed this document, as such you are waiving of your legal right, I can tell you this: that is not that simple and straightforward, that they can rely and get out of their negligence. So take an example. So even if that waiver of liability form that you even were read and you signed it and you took acceptance of that risk and you still were hurt in a park, that does not mean that you don't have a case. Because one thing I can tell you, if the property owner is still negligent in maintaining their property, or for example equipment, and as a result you suffered injuries, and people get seriously hurt in those amusement park, trampoline park for kids, their waiver will never protect them, and you will still have a case against the negligent facility owner. So we all have to keep this in mind. Never make a decision, or never make a decision based on what you were told by the facility owner or facility provider, but consulting an experienced personal injury lawyer who can go through all the information, who can look at the negligence part of the property owner or facility owner, and then make a determination whether or not you have a case or you don't have a case. I have seen many times people who were hurt and they just really do not consult an experienced, an expert lawyer in that area, and as a result, they are not given proper advice and they don't make a claim. And as a result of the injuries, they have been suffering for years, and especially in the situation of a child, that you as a parent, it is your responsibility, your legal duty, number one, when you take your child to a place, number one, you have to make sure that place is safe. And despite your best efforts that you are taking your child to a place or a trampoline park or some other playing ground, if a child being hurt, you still have a case. You have to make sure that you, when you buy a pass to enter to a amusement park or any such facility, you must ensure that you keep, the receipt for the payment, because also payment also make an obligation on the property owner that, when you pay certain fees to enter and use a facility, that create a further obligation on the facility owner, that they have to make sure that if they have taken money to provide a service, they provide a safe environment for the visitor. If you have any other question related to the issue that we have just discussed, or any other legal matter, please don't hesitate. Call us and speak to one of our lawyers at the office, or speak to me, and we'll be happy to guide you. Thank you for watching.